have, heads of compliance at schools all across the country who have never seen an endorsement deal or never seen a marketing deal for an individual athlete. They've seen sponsorship deals, right, for their school, but they've never. It's completely different. If somebody's going to pay you $50,000 to show up somewhere, what should they even be looking for? So they have no idea. So this whole thing has been crazy. So name, image, and likeness. That's what we're going to get into. We'll talk about, again, if you have questions, interrupt me, because, there's just us. It's just us. We're all fair. So name, image, and likeness, what is it? Name, image, and likeness, kind of technically and legally, it's your persona rights. It's someone's rights to their rights of publicity, their persona, and the ability to earn or have ownership of their name, their image, and their likeness. So your name is obviously your name. Image would be a picture of you, right? And likeness would be some graphic representation where we know who it is, right? So for me, it could be like, salt and pepper gray goatee, mole on my cheek, right? Like colorful sneakers, whatever. You'd be like, oh, I know, that's Luke Fedlam, right? And so that's kind of the formal definition. But when it comes to like name, image, and likeness at the college level, really what it means is student athletes being able to earn money by contracting with a third party for the license of their name, image, and likeness, and earn compensation in ways that they've never been able to before. So that could include things like I want to have a camp or a clinic where I put my name to it and I can get paid. And this is where, a lot of times people hear about the $1 million deals, these big, blockbuster deals, but a lot of student athletes are getting involved simply from the perspective of, well, I can go back to my hometown. I may be the first, D1 field hockey player from my hometown, and I can go and coach all these other, field hockey kids that want to be D1 players, and parents are going to pay me $50 a pop or $100 a pop or whatever it might be, and now I walk away with $1,500. So a lot of that, as well as the social media influencing, appearances, autographs, other kind of more traditional sports marketing deals. So for 70 plus years, student athletes, right? So 1952 is when the NCAA started offering athletic scholarships, which happens to also be the same year that there was the first television contract in college sports. It was for football. It was with the NBC. It was a one-year deal. It was worth like $1.14 million. Right?
Wow, things have changed.
Right. Exactly. Now, that's the crazy part, though, right? When you think about it. So we're now, March Madness kicks off today. It's a little over $1 billion a year. It's a total $20 billion deal with Turner Sports and whatever it is. So, I mean, when you think about it, that's just basketball, right? But the March Madness tournament accounts for over 85% of the NCAA's budget every single year, right? So that's why you knew that last year when they did it in a bubble, you knew it was going to happen, right? Forget COVID, because they couldn't go a second year without having the tournament just because of what it means to overall revenues. But then you think about it, in that time, the only thing up until July 1st of this past year, the only thing that changed for the student athlete was on the edges, right? On the fringe, where it was oh, we'll start to give you a cost of attendance allowance, or we'll give you some stipends here and there. But since the early 1950s to 2021, the only change for the student athlete was a few extra $100 here and there. But when you look at the sport in general, from what coaches are getting paid to the media deals and all that kind of stuff, it's exploded. Yeah. So this idea now of student athletes, a lot of people be like, even a little over a year ago, people were like, student athletes shouldn't get paid, all this kind of stuff. It's important to make the distinction between pay for play and name, image, and likeness, right? And pay for play is, hey, we're going to pay you to be here playing this sport, and we're going to pay you. And that is very much like the professional sports model, right? You come here, you play, you sign a contract, we pay you, that kind of thing. What this is, name, image, and likeness is just the opportunity, right? The opportunity for me that if I want to go earn money, I can do that. Yeah. Now, it also creates the opportunity for people to take advantage of it and to use it for recruiting inducements and all that kind of stuff. But guess what? For years, those things have happened, right? Mm-hmm. Not to say that they're right, but that's happened. Before, it just happened to be bags of cash, that were dropped off and accidentally left in a student athlete's living room or whatever, right, when they're in high school. Now it's okay, well, now you have to do something, right? You have to do something. You have to provide a service, and then if you provide that service, you can get paid for it. And why we see some of these deals balloon into multi-million dollar deals in some instances, there's a story just came out this past weekend. They didn't name the player, high school 5-star athlete, that signed a deal with a name, image, and likeness collective. I'll get into that a little bit later. But basically signed a deal that it could be worth over $8 million, right, for this high school student athlete to play college sports.
Real quick on that. Mm-hmm. So Quinn Ewers left early to come here because his high school wouldn't let him do it. Are high schools now allowing them to make money? Is that where we're headed?
So right now there are 6 states, right? So how high school works right now, there are 6 states that have authorized it for all high school student athletes. Okay. California, New York, New Jersey, Alaska, Nebraska, and one other one. And then there are other states that have it like in the hopper. So Maryland, their state legislature is voting on it, that kind of thing. But for those states, so those states, high school student athletes can participate. Other states are silent on the matter, right? Which is their public high school athletic association has said, we're not really taking a stand on it. So it's one of those things where it's this really weird gray area. And then others are like, absolutely not. This is not authorized and not allowed for high school student athletes.
Is that Ohio?
So that's Ohio. I mean, Ohio. So Doug Ute is the executive director of the Ohio High School Athletic Association. We've had a lot of conversations on this. He has a public stance on it, and he has a kind of a more private stance on it. I think ultimately, in the state of Ohio, all that it's going to come down to is a really elite high school student athlete just saying, I'm doing it, and just doing it, and then going through the whole process with OHSAA. Exactly. It'll be a test case, and I think as long as that student athlete's not using the OHSAA mark or their high school's marks and logos, then I don't think anybody's gonna stop them. Because even way before NIL, I've had situations when TikTok, early 2020, when TikTok kind of became a thing, I had different families reach out of high school student athletes who had the opportunity to earn money not related to their performance, right? So not related to their athletic performance, but just because like somebody created an in-house garden, right, on TikTok, and now Home Depot wants to have them be like a little influencer with product and things like that. And we went through the OHSAA, and they were like, yeah, it has nothing to do with their sport. They're making money and that kind of thing. That's fine, right? So there have been some of these little kind of things along the way that once somebody does it, I don't think they're going to stop it. My opinion. Yeah. But also at the high school level, if you go to a prep or private school that doesn't fall under the state's public high school athletic association, then you can engage too. So Mikey Williams, Bronny James, and others have had some big deals at the high school level, but they play in private high schools. In fact, it's kind of crazy. So my clients on the legal side historically have been pro athletes, but now they're a handful of college student athletes, usually the ones that are going to transition to the pros in a relatively short period of time. But we also have a couple of high school clients as well, which is crazy, right? I mean, ultimately the parents are the ones that are the clients because it's a minor. And
but in basketball, that's an acceleration though. From a senior in high school to be an NBA star is an acceleration.
Yeah, absolutely. And so from that perspective, that's kind of where we're at high school. So the question a lot of times that I get is like, well, how do we get here, and like, where are we going, right? Where's all of this going to go? And so we got here in a really kind of interesting way that I think sets a good context for ultimately where we can go. So in 2019, California state legislature said, you know what, we're going to come up with this bill, House bill or a Senate bill at the time, 206, and it's going to allow college student athletes in California, in the state of California, to earn compensation from their NIL. And California sometimes is a pretty creative first mover in some of these things. And LeBron James and others kind of got behind it, like, absolutely. Yeah. And this is kind of following to the Ed O'Bannon case. Ed O'Bannon was a basketball player at UCLA. He sued the NCAA, EA Sports. He basically shut down kind of college basketball and EA's college basketball and football. And so, and that was a case tried in California in federal court. So California was right for being the first state to do this. And so they ended up passing this in 2019 and said, you know what, NCAA, we're going to work with you. We passed it, but we're not going to make it effective, have an effective date until January 1st of 2023, right? And so it was like, okay, NCAA, you're on notice. You need to come up with something because NCAA regulations can't trump, state law. Like, state law is state law, and NCAA regulations are just rules. So state law is going to prevail. So the NCAA was pretty much put on notice, like, you have to do something. You have to come up with something because, the state legislature could always say, if the NCAA comes up with something legitimate, then we don't have to have our law on the books, right? Or it could be in line with what our law says. So they created a working group, legislative working group. Val Ackerman from the Big East, Gene Smith here at Ohio State, were kind of led this legislative working group on name, image, and likeness. And so they started working through kind of summer, fall of 2019 into 2020 on kind of some what this might look like. And then Florida said, hey, California, like, we see your 2023 and we're going to raise you 2021. And they basically said, Florida said, we don't care about what California's doing. We're going to pass our own NIL legislation and we're going to make it effective July 1st of 2021. And that's what changed, like, the game, right? Because now it's like, we don't care what you're doing, NCAA. we're going to do our own thing. And now other states were like, well, hold up, if Florida's going to do this in 2021, and now we're in 2020. And so now that the legislative working group for the NCAA really accelerated things. And so we have this crazy period of time, right? We're in COVID, sports are kind of shut down, and then they're trying to come back, and we're trying to figure out what does this NIL thing look like. And most people believe the NCAA is going to figure it out, and they'll pretty much shut down these individual state actions, and will really just come up with something that makes sense. Or they'll figure out how to just shut it down at all, right? And really lean on the amateur status of college athletes. They shouldn't get paid, shouldn't make money. So you go into the fall of 2020 and into winter 2021. Fall of 2020, the NCAA, the working group, came up with their proposed regulations. It went through kind of their process, their governing process of the NCAA. And it was these proposed regulations that said student athletes can earn compensation off their name, image, and likeness, and it had a series of rules around it, right? You can't use a school's marks and logos. You can't do NIL deals on college facilities like college campus. You can engage with a third-party professional service provider. All these kind of rules that were 3 or 4 pages worth of rules for this. And so they were set to vote on it January 11th of 2021. It was going to be the D1 council was going to vote on it, then D2, then D3. And so that was a Monday. And on Friday, the Department of Justice said, hey, we think you have an antitrust issue here. We highly recommend that you don't vote on this, because ultimately what you're trying to do is limit compensation and whatnot for a class of people broadly that could be seen as like anti-competitive, and there's some bigger issues here. And so the NCAA said, okay, all right. So they did not vote on it. And when they didn't vote on it in January, that's when we saw February, March, April, states across the country started racing, right? Because now it's like, well, we're not going to lose out to Florida. If the NCAA is not going to do anything about this, we have to make sure that we're protecting ourselves. And it's interesting because then we had a flurry of states that all passed name, image, and likeness legislation. And it's interesting, right? Because we're probably since the 1700s, we're probably the most politically split that we've ever been, right? And it's like, but the one thing that will pull Republicans and Democrats together in state houses all across the country is sports. And it's like, if I'm a Mississippi Republican and you're a Mississippi Democrat, we're going to agree on football that we don't want to lose out to Georgia, right? So these states were like passing legislation because now it's easy. All we have to do is say, hey, student athletes in our state can earn compensation off their name, image, and likeness. Maybe they put in some restrictions on it, but ultimately these were getting passed left and right. Yeah. You've got, at the same time, this court case that's kind of working its way through to the Supreme Court called NCAA versus Alston. So in March, towards the end of March of 2021, there's this NCAA versus Alston case. Now, as I said before, I don't really go to the courtroom. I don't really follow like cases. That's not my thing, except for this one. I was in my office. It was in the morning when they had oral arguments. If I had popcorn, I probably would have been eating popcorn. But I had my feet up on my desk just listening to these oral arguments where the Supreme Court justices were interrogating both sides, the NCAA, and they let the NCAA have it. But then on the flip side, they also let the Alston parties have it too. Now, the case itself wasn't about name, image, and likeness. What the NCAA versus Alston case did was it focused on a singular issue of education-related benefits. Education-related benefits are things like providing student athletes a laptop, giving them a stipend for going to study abroad, giving them, an iPad for learning, and different things like that. Like giving them things, right, that are ultimately related to their education-related benefits. So the question before the court was, is it because the NCAA limited that amount, right? You can only give, as a school, you can only give up to so much to a student athlete in these education-related benefits. So the question was, is it an antitrust violation for the NCAA to cap or put a limit on education-related benefits for student athletes? That was the singular question. They could have gone a lot of different ways with a lot of questions around complete compensation, around name, image, likeness, and all that, and they didn't. They stuck to one singular issue, which I think was the best strategy for the Alston parties, because you allowed the court to just focus on one thing. So that's now March, where they hear oral arguments. We're still speeding towards to July 1st. They hear the oral arguments in March, which means we're probably going to get a ruling in June. So now states are like, well, shoot, we really don't know what's going to happen. So more states are passing it. Here in Ohio, we had legislation, right? Ohio State worked with some legislators and others. I had a chance to see it, what the legislation looked like at first. They presented all this kind of stuff. It's going through. Then somebody, the last minute, they added in a completely unrelated issue to this name, image, and likeness matter, which kind of blew it up in the State House. But that's when Governor DeWine said executive order. So he signed an executive order authorizing name, image, and likeness for student athletes here in the state of Ohio. Kentucky did the same thing through executive order. I believe Illinois did executive order as well. And then other states now have also passed it, because we're like, we're moving into June now, and the NCAA isn't doing anything because they're waiting for the results of the Supreme Court case. States are like, well, we have to do something if we want to compete, because as of July 1st, we don't want to lose out on recruits who will very clearly say, well, why would I go to, University of Vermont, where I don't get anything, when I could go to, somewhere else and get paid. So we have the craziest kind of 2 weeks that then are about to happen in college sports in the middle of June. So June 20-something, 22nd, 23rd, something like that, is when the Supreme Court came out with their decision in the Alston case. And that was a unanimous decision, which, talking about our politicized society, when the Supreme Court does something unanimously, it's like mind-blowing, because that never happens. And they were unanimous against the NCAA, saying, NCAA, it is an antitrust violation for you to limit and put a cap on these education-related benefits. And so the last time prior to this case that the NCAA was in front of the Supreme Court was 1984. It was this court case called NCAA versus, it's called the Oklahoma Board of Regents case, where ultimately it was against the NCAA, where they were trying to work out media deals. Who had the right to do these media deals? Was it the NCAA? Was it the conferences? Was it the schools and things like that? And there's, in a court opinion, there's this thing called dicta, which dicta just means a judge says something, but it's not the holding. It's not the actual ruling of the case, but a judge says it in their opinion, right? And in that opinion in 1984, one of the justices had talked kind of about the NCAA potentially having this antitrust exemption, right, where they were exempted, broadly speaking, and could limit and put caps on all kinds of things, right, to control this product called amateur sports. But college sports in 1984, way different from college sports in 2020, 2022, etc. So the NCAA had been relying on that dicta for years to say that we can do what we want. We can set up all the rules that we want. We can put limits on things that we want. This case, the NCAA versus Alston case, has completely blown that up. So at this point, it is very clear that the NCAA does not have an antitrust exemption. And in the unanimous decision, it talked about how, hey, NCAA, you can't do this. You can't limit this, right, on education-related benefits. And then in the concurring opinion, Justice Kavanaugh, 2-3 pages long, not too long, but blistering of the NCAA, ultimately saying, you're lucky that we only have talked about education-related benefits. But if you try to limit any type of compensation to student athletes, then ultimately you will lose under the court's decision here. In our process of our analysis, you will lose again. So it basically said, like, you can't, that concurring opinion, I think the NCAA, had there not been the concurring opinion, the NCAA might have still tried to skirt the issue and say, well, NIL is different because the court didn't say anything about it. They didn't talk about any other limitations. So it's different. So maybe we can still control it. But with that concurring opinion, there was no gray area. It was very black and white. And so because of that, that was, like I said, June 22nd-ish, 23rd. That meant there were 7 days until July 1st hit. And so schools at that point, so 2 days after that, the NCAA Board of Governors said, hey, schools, here's the new name, image, and likeness rule. We're not making the rule. Ultimately, we're going to leave it up to you. And so we're going to say, yeah, right, exactly. We're going to suspend the bylaws that prohibit student athletes from earning compensation. And if you are a school that's in a state that has a state law on name, image, and likeness, then your school policy on name, image, and likeness just has to follow state law. If you're a school that's in a state that doesn't have a name, image, and likeness law, then you can do whatever you want with your policy. And so that's where we started on July 1st, where it became all student athletes can earn compensation off their name, image, and likeness. So we've seen all kinds of different deals, all unique ways of student athletes making money, but we have the opportunity to work with colleges, universities all across the country, and I have a lot of conversations with athletic administrators, athletic directors, coaches, etc. And the crazy part is this is all changing so fast that, like, the policies that they created on July 1st, most schools have changed their policies, and most schools have changed it multiple times to try to keep up. Here's an example. This time last year, March of last year, there was a belief that no school was going to allow student athletes to use their marks and logos. I've had so many conversations with Ohio State, right? They spend millions of dollars protecting their Block O, protecting, everything related to Ohio State. And schools across the country do that because part of intellectual property law, trademark law, is if you don't protect it, then you lose the rights, right? So institutions have spent millions and millions of dollars protecting their rights. That was a year ago. Now, most major programs have a plan or program in place. Most schools have a program in place where student athletes can license and use the school's like marks and logos, right? A significant departure. And now they do it through group licensing and through some other programs that they have where student athletes can opt in. Now the school makes a little bit of money, as well as the student athlete on various types of apparel and other kinds of deals like that. Some schools have just outright said you can just use our marks. It benefits us. It's more advertising promotion for us and things like that.
But most of them have a collective where they opt in and everybody shares the revenue.
Most of them have a group licensing deal where they can opt in. Yep, and they can share in some of that. The collective that you bring up is something else that's like really been created. A year ago, nobody said the term NIL collective, and now it's like commonplace. So an NIL collective is basically a fund, and it's a fund where fans, donors, alumni, boosters, etc., can put money in, and student athletes, really for this express purpose of student athletes earning NIL compensation. So it's interesting because we've seen a couple different ways that these funds have been created. One on the nonprofit side, one the for-profit side. So on the nonprofit side, I think it's going to be real interesting to see if the IRS comes out with some type of determination letter at some point in the future. IRS is backlogged and all this stuff. But it's hard to say that there is a charitable purpose, that you're furthering a charitable purpose by just paying a student athlete to go out and show up somewhere, right? But some schools, and when I say schools, the collectives around a school, because a school can't create its own collective, right? Because
so these are people like Cardell Jones and
exactly right. Brian Schottenstein. Yeah, exactly. And I'll tell you, just even with Ohio State, there are 3 different groups right now, all looking to create collectives for different groups. One that's looking at all student athletes at Ohio State. Some that are looking at just basketball. Some that are looking at basketball and football. So it's all over. That's most schools, right? Most schools are trying to figure out, because it's this interesting like dance, right? I mean, it really is a dance because the school itself wants to recruit the best talent, right? Fans, donors, boosters and all that, they want that school to recruit the best talent and be able to retain the best talent. Because don't forget, we have transfer portal now where student athletes can transfer without having to sit out for a year. So now it's not just recruiting, it's also retention and how do we keep our athletes that we want to make sure that we keep. But schools can't direct money to student athletes. That's the big issue. So that's why it has to be this outside group, this outside fund. And so we've seen some really interesting ways that they've been set up in different schools across the country. And I think my professional opinion is that we're going to hear some horror stories over the coming years of mismanagement of funds, all this kind of stuff. And the NCAA is in a real kind of unique situation where they're trying to, they won't use the word investigate, but they're trying to study, I think is the word they use, some of these different name, image, and likeness programs at different schools. Because the key is you still have to provide a service. The student athlete has to provide a service. So when NIL first kind of launched, a couple of schools. One, you might have heard at Miami, University of Miami, football, like some wealthy, donor said, I'm paying every football player $500 a month for 6 months or whatever. So every football player is going to get $6,000 or whatever, to do nothing, for being on a football team. Yeah. And I want to say BYU, some big kind of sponsor donor to the university came in and said, everybody that's a walk-on, we're going to pay for your scholarship. We're going to give you a full ride scholarship. And those are stories that sound great, but they really aren't name, image, and likeness. And so the NCAA is looking into them and others because the student athlete still has to provide a service. Like now, what you end up saying is like, well, it could be BS, right? It can be a BS service. It can be like, oh yeah, like Steve, send out a couple tweets to your 800 followers or whatever and pay you $500,000.
Yeah,
that doesn't make sense. But the issue is that there's really no fair market value set. Like the market value of all this isn't set. Now at the pro level, there's kind of a knowledge and understanding, but this is where pro sports are way different than college sports. Fans of college sports, boosters, donors, etc., it's way different than at the pro sport level, because at the pro sport level, there's this belief of like, well, they're professionals and they're getting all this and everything like that, and my allegiance to them, while I may be a rabid whatever, I'm a diehard Eagles fan, Like if I'm a diehard fan for this team, it's not the same as like my college experience where I can be closer to it. Maybe I went to school there. I can donate and get access, right? I can be a big donor and be able to be in the private club in the arena and walk out onto the floor, all that kind of stuff. And it's just different. So the money has been different, and we've seen ridiculous numbers going to athletes. You brought up Quinn Ewers, right? So that's an interesting one where he was in Texas. Texas didn't have the high school rule. He finished his senior year, but just basically graduated early, right? I mean, he had the credits and all that. Which, as a complete aside, I didn't know that was really a thing. When I was in high school, right? Who graduated early? Tell you, right? And you just get what you need.
Summer school, man.
Right. Like, it just made no sense, and it wasn't made real to me until one day we had to move. I hurt my back. I threw my back out, sign of old age, and we had to move a dryer from our basement up until like our main floor. So our neighbors have like some teenage kids. They're like, oh yeah, they can do it for you, whatever. Cool. All right. They come over at like 1 o'clock in the afternoon.
Yeah.
I'm like, aren't those guys at school? They're like, oh well. One of them, he was like, I just take classes in the morning because I'm pretty much done. I could have graduated, early or whatever. Yeah. And the other one's like, yeah, I'm already taking college classes and all that or whatever. I'm like, it's a completely different world. Yeah. But for Quinn, so he ended up, leaving, came to Ohio State, $1.4 million deal. I believe it was over 3 years. Was here for a year at Ohio State and transferred. And so in that instance, you have these situations where companies and brands are having to become smarter about how do they engage with student athletes. It can't just be like, okay, hey, yeah, I'm gonna give you $1 million and you just send out some social media stuff and this and that, because you have to protect yourself. Like, what if they transfer, right? What if they end up going somewhere else? Interestingly enough, what if they suck, right? I mean, bottom line, right. What if they get hurt? Spencer Rattler, right, was probably one of the biggest names, right, as a quarterback at Oklahoma, and then he ends up getting, benched for Caleb Williams. Side note, Caleb Williams, who then transfers from Oklahoma out to USC to follow Lincoln Riley, and has already signed multiple LA-based kind of NIL deals. One of which is interesting, is for equity, right? Where he has equity in a cosmetics company because he likes to paint his fingernails. That's kind of become his signature thing, and so it's this whole cosmetics company. Now he has an equity stake in that business. That's where I think we're going to start to see a lot more creativity in this NIL space. And, just even thinking about it from a tax perspective, I just had a long conversation yesterday. There was an article that came out about how some elite athletes will get, especially on the football side, will get insurance policies. They'll get like, this is good. We're going to have interactive. For anybody listening, we're about to have an interactive session. I have a question for you. So there's this article that came out, and it talked about how, college football players in particular will get disability insurance policies to protect them in case they get injured, right? And they're really draft eligible, gonna go on to the pros. And the permanent total disability insurance can be incredibly expensive, right? The premiums on that could be in the hundreds of thousands of dollars. So the article kind of proposed that if you're a football player that, let's say, makes $1 million in NIL, right? You're an independent contractor, you're going to have to pay taxes on that $1 million, right? 1099 income, boom, you're going to pay taxes. But if you have an LLC set up, and you do a permanent total disability policy, that premium payments of a couple $100,000 could potentially be, right? Just your reaction is exactly what I think. There are some accountants that will say, like, yeah, you can take that as a deduction. And others that are like, I'm not so comfortable with that, right? And that's where this whole kind of like space is interesting on a whole bunch of levels. Number one, the student athlete doesn't understand any of that. No. Student athletes don't understand what's an LLC, why do I need it,
we don't get it. So right? How can they get it?
You're right, exactly. Right? But then even on the insurance piece, it's like historically schools have paid the insurance, which means if the schools pay the insurance, you're not going to get any, tax benefit from that because somebody else is paying for it. But it's those kind of things that continue to make this NIL space really tricky and interesting, and that's what gets me so fired up, because we get to talk to everyone. Anybody heard of NFTs?
Yeah.
NFTs, right?
Yeah.
Non-fungible tokens, etc. So we talk to coaches, athletic directors, all the time about NFTs, because student athletes are wanting to get involved in these NFTs, which is basically, if you don't understand them, they're basically like a digital trading card. Instead of a old school baseball card, it's like now this online digital card that's backed by cryptocurrency that allows you to have some authenticity around like that specific serialized, individual NFT. But they're fraught with money laundering, all right? The Treasury and the government basically are still trying to figure out how to regulate all of it. And then you've got, situations where Student athletes don't even understand like the intellectual property side of things. Like they think, oh, I can just make it. They don't understand how they get paid. But these are areas where athletes are getting taken advantage of or getting put into these things. They don't even know what they're doing. So the good news, I think, for me is that I'm going to be busy and continue to be busy for hopefully a very long time.
The future is good.
The future is bright. There's a lot going on. But I'll tell you, when we look at the future, and the reason why I say that, and I'll wrap and happy to take any questions and talk about this stuff. I can talk about this stuff all day. Is that nothing's going to change anytime soon, right? We're going to continue to keep growing and pushing, and it's going to continue to be the wild, wild west. One school's going to figure out, hey, we can do it this way, and then all the other schools are going to follow, and then somebody else is going to push the envelope for innovation that way. Because there's only really two organizations that could restrict what's going on. The NCAA, which we know because of the Supreme Court case, they can't do that now, and Congress. And Congress is dealing with infrastructure, a war in Russia, Ukraine. I mean, there's so many other things that pushes NIL and the payment of student athletes very far down on their legislative agenda. And so it puts this kind of situation out here where schools are going to continue to push the envelope and do what they do. And I'll tell you, I've had opportunity to have conversations with Kevin Warren, the Big Ten commissioner, Commissioner Phillips for the ACC, as we worked with the ACC on some things. They hate it, right? They hate it because if you're a conference commissioner, you've got schools in multiple states, right? So your schools are following different policies. Like there's no standard, there's no uniformity around all of this. But that's the world that we're going to be living in. So I think we're going to continue to see some really unique and different deals. And then lastly, I'll say, because I do get this question quite a bit around women's sports and asking about are women student athletes having the same opportunities that male student athletes are having? The thing with name, image, and likeness is it gives anyone the opportunity. Most women student athletes have a more engaged social media following. The number one team with the highest social media engagement in college sports 2020, which is the last year that the data is available, was UCLA women's gymnastics team. So, and there are actually a few women gymnasts who are seven-figure NIL folks as well.
Real quick, Luke, just for our listeners here, because we're right at the end of the video time. If you run across someone who has a kid that's an athlete, or even the athlete themselves, what do we do? What do we say? Who do we send them to? How do we get them to you or someone like you?
Yeah. So this is the hardest thing here because for us, I'm in a law firm and we charge our law firm rates, right? So when I work with college student athletes, it's really those student athletes that have significant compensation coming in for NIL because they can afford me, they can afford us, and there's only so many hours in a day. But the key though is if they have questions, like I answer people's questions all the time. Like we have conversations. If people that are listening online or here in the room that want to talk more about it, you and I set something up and we just say, hey, come on down and we'll do a Q&A session. Right? Because that's a lot easier to just answer groups and a lot of questions at one time, because it is understanding things like, should I set up an LLC or should I not? If I want to engage, how do I engage? How do I protect myself? If I start getting paid, now how do I manage that? All that. So there's a lot to it. But it's really important to understand the business side.
And as a follow-up in 45 seconds, who should they not talk to and why?
Be careful of agents, marketing agents, or other people who say, we're going to go find you deals. Because ultimately, if anybody wants you to pay money in advance or up front, and we have seen that already, where it's like, hey, pay me this much, I'll grow your social media following, or I'll go find you deals and stuff like that. No. If they get paid, they should only get paid if they find you actual opportunities.
Thanks
for listening.
Appreciate you, man.